When an injury happens on holiday, due to the fault of another party, the injured person may be entitled to bring a holiday accident claim under Irish law. If an Irish person is injured while on holiday, they may be assessing where they can activate a legal right. This information post will give you information about this issue in an Irish and EU law context. It is not designed for information purposes if the accident occurred outside of the EU. Jurisdiction. A first issue to address in a holiday accident claim is: where did the accident occur? I.e. country. Where does the injured party reside? Where does the defendant reside? If the accident occurred in the EU, then EU law will be relevant. An Irish citizen has rights under Irish law, but also EU law. If the incident occurred in Portugal or Spain, for example, evidently the party can attend for legal assistance in those countries. There are safeguards, however, under Irish and EU consumer protection laws relevant to Irish and EU citizens. If you wish to pursue the matter in Ireland, your solicitor will advise you of jurisdictional matters after reviewing your paperwork, case facts, Irish and EU law. If you are injured while on a package holiday, Irish law can offer consumer protection mechanisms. The law, commonly referred to as the Package Holidays Act, primarily the Package Holidays and Travel Trade Act 1995 and strengthened by the 2019 EU regulations, is designed to make it easier for travellers to activate a legal right in Ireland when something goes wrong abroad. If the case matter can be brought under Irish law, the case must proceed to the Injuries Board in the event of it being commenced. The Personal Injuries Board deal with personal injury claims in Ireland. To initiate a claim, one must submit a claim vis-à-vis post or by submission to their website. The board was established by the Personal Injuries Board Assessment Act 2003. An application is submitted with the application form A and a medical report together with the administration fee to the board. Once the personal injury claim is lodged, a Section 50 claim registration letter notice will issue. The Injuries Board will proceed to notify the alleged wrongdoer of the claim, who has a 90-day period to consent or reject the assessment. If they reject, the matter cannot be dealt with by the Injuries Board. If the Injuries Board proceed to assess the claim, they will make what is termed an assessment, which is an assessment of damages. The injured party is entitled to accept or reject the Injuries Board assessment damages sum. The respondent is also entitled to either accept or reject the Injuries Board assessment of the claim. Should both parties agree to the Injuries Board assessment sum of damages, the matter can conclude and an order to pay furnished. If the matter is not concluded in the Injuries Board, then court proceedings may be necessary if the injured party wishes to activate a legal right. If the injured party is a minor, they cannot commence a legal action. It is their next friend that is parent in this circumstance. If you have any questions, our contact details are 01 54611121 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.